All right, we are now live. Good morning, everyone. The time is 11:02 a.m. on February 23rd, and I'm calling this meeting of the Election Law Subcommittee to order. This is our very first meeting of the Election Law Subcommittee for this term, and I'd like to welcome our new members to the subcommittee, Delegate Miller, Delegate Fair. So welcome. We hope that you enjoy the time and brilliant debate and discussions with us. So just a few matters of housekeeping. We do ask, just because of the way that YouTube works, and we do stream all of our meetings on YouTube, that if you're not a member of the committee or council or Jared Demarinis, if you can be off camera so that we can make sure that the members in particular are able to be seen. For also, I don't think we have any on here, but as a courtesy, I do always notify bill sponsors that their bill is being discussed and they're welcome to attend. However, they do not have a speaking role or a participatory role unless we call on them for some reason, but I do allow them to listen in or watch or be present in case we have any questions. There's more of an FYI for them. I think those are the main housekeeping items. We'll try to be as timely, and for new members, you'll notice as session gets more fast paced that sometimes in meetings you have very little notice, but we try to give as much notice as possible and try to make sure everyone has the information ahead of time. But amendments will get to you when they're drafted. Stan is drafting all those committee amendments for us, so things kind of get to be moving very quickly. So if you can pay attention to the announcements and any messages, then that would be great. So with that, we do have 3 bills today that we're bringing up, and I will always try to give a heads up on if we are voting or if we're just discussing bills so that you can be aware. So you'll see the distinction today that we do plan to hold a vote on HB 192 if there is readiness, and then the other 2 bills are for discussion. So let's go ahead and start with HB 192, cryptocurrency, campaign finance prohibitions, disclosures by financial institutions. As introduced, this bill prohibited a campaign finance entity from depositing or authorizing a disbursement, authorizing a contribution, making a contribution, accepting a contribution, if it was a cryptocurrency. So and none of that dealing with cryptocurrency. You do have an amendment that is in the form of a reprint. So for the new members, sometimes instead of just sending solely the amendments on the bill, there are just so many amendments that we just do a reprint of the whole bill. So what you received was a reprint that basically just shows all of the markup and what the new bill would look like with all of the amendments. So that's what you have there is a bill reprint that we sent out not too long ago, but we are going to spend some time walking through it so that everyone's comfortable and understands how the bill looks now. But in summary, what the bill as amended would do is that all the things that I mentioned in terms of the prohibition on depositing, authorizing a contribution, making contribution, it just changes the bill so that it clarifies that these things can only happen with US currency. The bill will no longer specifically talk about cryptocurrency. It's just clarifying that you need to use US currency for all of these transactions. So I'll turn it over to Stan to talk more about the reprint and the bill as amended, and then we will work on adopting the amendments and discussing the bill as amended.
Thank you, Madam Chair. Yeah, so basically that is exactly what it does. One important clarification is that it does still allow for contributions to be made in kind, because current law does allow that. So basically it just says if you're using currency to make a contribution or a donation to an independent spender or an expenditure, then it has to be United States currency. So that's what it does. I know that Jared had suggested, just to make it extra clear, that we're not banning in-kind contributions, that it's a monetary contribution, which is not in the reprint, but it's a change that you all could choose to adopt if you want to. And then I also wanted to just ask Jared, do you feel that monetary also needs to be specified for donations and expenditures, or is just contributions sufficient?
I think so. For just consistency's sake, just to have it so that it's across the board, and that would make sure that in-kind contributions is clearly still acceptable, and make it that this is only for currency transactions or use of credit cards, or anything that the campaigns can make or expend. And yes, this that would just kind of tighten it up, just to make it 100% clear. So thank you, Stan. Yeah.
Sure.
Thank you.
Thank you. The only other thing, Madam Chair, is I just wanted to highlight that there is that provision in the bill about the comptroller being able to request information from virtual currency transmitters, and then also they would be able to enforce a lien by going after assets in a cryptocurrency account. That's also in the bill, just to remind the subcommittee of that.
Repeat that again, Stan. You started talking about liens. Wait, can you say that again?
Yeah. Yes, the bill also, because it dealt generally with cryptocurrency, it also included a provision allowing the comptroller to request information from cryptocurrency money transmitters, and then also to enforce liens by going after assets in cryptocurrency accounts. So that was a tax enforcement provision that was also in the bill, because it was generally about cryptocurrency.
And is that in the reprinted version?
It is, yes.
Okay. So where page is that on the reprint?
So in the reprint, you can see that on, let me scroll down, it's the end, starting on page 6 of 7. And then the key provision is down on page 7. It just adds a virtual currency money transmitter to this list of entities that the comptroller of financial institutions that the comptroller can request information from.
Oh, okay. Right. Okay, that makes sense.
To enable enforcement. So they can already do this for credit unions, banks, and all of that.
Right. Okay, so what I'm going to ask, and I see Delegate Miller with a question, but just for proper debate and a discussion, I'd like us to adopt the amendments and then have discussion on the bill as amended.
I'll move the amendment.
Second.
It's been properly moved and seconded. Any further discussion? Seeing none, all those in favor of adopting the amendments on HB 192, say aye, raise your hand.
Aye.
Any opposed? All right, let's discuss HB 192 as amended. Delegate Miller.
I don't understand the money transmitter, the currency, the virtual currency, because like crypto is more untraceable. So how exactly does that work? Is there a brief explanation or anywhere I can go to get information about that?
Yeah, so the sponsor's testimony has a good discussion of that on starting on the 2nd through the 3rd pages of this Delegate Plakovich-Carr's testimony. But apparently, and I'm not as familiar with this aspect of things, but apparently there are some cryptocurrency exchanges that are already regulated under Maryland law and are registered, including Binance and Coinbase. So that would apply to them.
Okay. So would it make like anyone that has to do it then would have to register for this transmitter part if there were other currencies that didn't apply to that?
So this doesn't change anything about who has to register. That's just current law. So this doesn't change that. It's just if they're a registered transmitter, then the comptroller could request information from them and, attach assets and cryptocurrency accounts managed by those transmitters that are already required to register.
Okay.
All right. Any other questions, comments, concerns, or discussion on the bill as amended? Let's discuss the potential verbal amendment regarding adding, I guess, monetary, which I think sounds fine, just cover our bases. I think we all want to continue probably with in-kind donations, but so the word currency and the word monetary, that doesn't cover that we're talking about money, actual money.
The bill doesn't include the word monetary right now. It just refers to currency. So this would just say, basically it would say, a person may not make a monetary contribution using any currency other than United States currency. A person may not make a monetary donation using any currency other than United States currency, and so forth.
Okay, monetary. So a monetary contribution, monetary donation,
monetary expenditure, so forth.
Delegate Feldmark.
Thank you, Madam Chair. I would just say, I don't feel like it's needed because I think there's no confusion that an in-kind, food or, venue or whatever is not currency. But I also think it probably just for an easy read makes sense. Like, I don't think it's necessary, but I think it does help clarify.
Is it possible to just add a line in the bill that says, something like, this doesn't affect in-kind contributions, or some kind of like clarifying line there?
I think as a matter of drafting, I guess it could, I think as a matter of drafting, it would probably be better to put that clarification in each actual sentence, just so somebody doesn't have to look somewhere else to see a clarification. But I think Delegate Feldmark, I agree with Delegate Feldmark's reading of the amendments.
Jared, you can go ahead and add.
Thanks, Madam Chair. We've used that term monetary contribution as for a definition of transfer too. So like when you make transfers between political committee to political committee. So it's a term that is a kind of a already used. So I just felt that it just would tighten it. And with this new, I would say, technology and currency that is being kind of adopted out there, that wouldn't, it just clarified it 100%, and there is no interpretation then. Like I said, I think the delegate and Stan is correct for enforcement purposes without the word, but this kind of, there is no doubt with that one additional word, and I think that would probably be best to put it in front of monetary contribution, monetary donation, monetary expenditure, and that would be consistent with another term like transfers, which is a monetary contribution to another political committee, just how it came about. So
you're basically saying it would make it more consistent with how we describe it, how we make these descriptions in other parts of our election law statutes.
Yes, right.
Well, it doesn't hurt. Is there interest in moving this amendment in concept, which would just add the word monetary before contributions in reference to the don'ts, the things not to do?
So moved.
Can I get a second?
Second.
All right, it's been moved and properly seconded. Any further discussion about this amendment? Seeing none, all those in favor of the amendment to add the word monetary, please say aye, raise your hand. Any opposed? All right, the ayes have it. We have the bill as amended with the reprinted amendments and the additional monetary added throughout. How about, I don't know if there's any more discussion on the bill or if we want to go ahead and vote it. Any further discussion? Okay. Delegate Fair? I don't know if I can hear you. I don't think I can.
can't hear.
Is your, did you turn the computer sound off?
Is this,
Oh, yep, okay.
okay, sorry. I move on a favorable report as amended for the bill HB 192 as amended.
Second.
Awesome. All right, it's been moved and properly seconded. Any further discussion on HB 192? All right, seeing none, all those in favor of HB 192 as amended, say aye or raise your hand.
Aye.
All right, the ayes have it. HB 192, our very first bill out of subcommittee on a bipartisan vote, unanimous. Look at that. Okay. Now, we're done on that bill. Next, or the next bills are just for discussion. HB 441 relates to draft committees and exploratory committees. And for everyone, a draft committee is an entity that's created to encourage someone to run for office. And it's not in coordination with the candidate that you're trying to recruit. And the candidate you're trying to recruit can't already have announced that they're running or can't already be a candidate or have an exploratory committee. So these are people, we've all seen them before, draft delegate Griffith for US president, you know, those kinds of things. The exploratory committee is created to determine the potential candidate's viability. And so these are two different things. The exploratory committee is usually created by the candidate themselves, whereas the draft committee is other people. The bill basically applies all of the campaign finance rules that political committees have to these draft and exploratory committees. And I'll turn it over to Stan if there are any additional details of the bill currently as drafted that he wanted to flag.
I don't think so, Madam Chair. I think that pretty well describes it.
Okay, now Delegate Jones, since you're here, I know there were some amendments that you described during your hearing that you were interested in. I don't know if there's anything that you want to flag or say further about this one.
Thank you so much, Chairwoman. So the amendment should be with your reprint. If you all are looking at the reprint, it's all right there. And what the amendment does.
Sorry, Delegate, I don't think we ever got, you had the amendments drafted. I don't think we got them.
Oh, I'm so sorry. I thought that we sent it. We have the reprints and everything. I'll be sure to send that along again.
No problem.
Apologies. Essentially, the substantive amendment, it included provisions for reporting procedures, removing contribution limits, expanding the list of permitted expenditures, clarifying that a candidate committee can purchase supplies at fair market value, adding a list for the use of leftover funds, and a 120-day deadline for the reporting of such records after the candidacy has been filed, right? So that's just a synopsis. I'm not sure where that got caught in the ether, but we have it and it's coming straight to y'all.
Okay, no problem. It's just a discussion day, so no worries. So it sounds like those amendments are to add some specifics that really only apply to like exploratory or other committees, kind of adding in some additional things that might not apply for political committees. Is that what it was trying to do?
Well, and it's that yes. Well, for the 120-day deadline for reporting, it also the fair market value is really about that draft committee or exploratory committee not being able to, they bought a brand new printer. It's a big, shiny, brand new printer that they love. And they can't turn around and sell that printer if they decide not to run or to run for $20,000, right? Like these are all hypothetical situations, but that has to be fair market value. So anything that this exploratory office would have. And the reason that we had 120 days is really to aid in that exploratory or draft committee to have the time to discontinue rent and turn off cable and internet and all of those things, pay vendors potentially, and then have everything shut down and tied into a bow appropriately. So that's where that number comes in.
Gotcha.
And this is also looks exactly like the Senate version, for which it had a hearing last week. Time's kind of a flat circle.
Delegate Griffith.
Thank you, Madam Chair. Quick question. So say it's a delegate who then creates an exploratory committee to run for Senate. They can't do that. Or can they do that?
It can.
And so what happens in the case where, say, Delegate Mike running for delegate, but I have exploratory committee for Senate, and I raise a bunch of money on that exploratory committee and decide to stay a delegate, what happens to those extra funds?
Maybe Jared can discuss his regulations on this.
I guess that under current law right now, a candidate, if you have a candidate committee, you cannot open up an exploratory committee.
Okay.
Because the current law is you can seek any political office you want, right? So it's tied to you as an individual, not to the office that you're seeking or holding. So that's why you can have people run, I use this really, why people run for mayor of like Baltimore and then can run for House of, delegates, because they're on two different cycles. But, you can seek any office on the Maryland ballot because we have a 4-year election cycle. And it's tied to giving to you as an individual. So your question, like if you want to run for Senate or county exec or whatever, it's still, the $6,000 limit applies for the 4-year cycle, whatever office you seek, which is why the exploratory and draft committees are for non-candidates. These are for individuals who never opened up a candidate committee, because in a sense that they're outside the avenue here, and they're deciding on whether to be a candidate.
Right.
And so it's a little bit different than what most people think of, like for exploratory activities, like for president, like you hear now, like I'm exploring this bid. If you were a governor or anything, they open up different accounts. That's federal law and completely different. Here, the only ones that can explore are non-candidates.
So the individual supporter $6,000 cap is still there, and there's no opportunity to double dip under this bill.
Well, see, I'm sorry, I misspoke earlier, and I wasn't focusing on the fact that in your scenario, it was a current office holder. And of course, Jared's completely right about that. But I was thinking more about your other question about if you do have an exploratory committee as a non-candidate, what can you do with the funds, and can you double dip? And that was why I was referring to Jared's regulations. So in terms of double dipping on contributions, if you lawfully can have an exploratory committee, yes, you can. The contribution limits don't apply to the exploratory entity.
Well, answer the last question. So say a buddy of mine creates an exploratory committee, raises a bunch of money, decides not to run. Can they transfer $6,000 of that, or to me, even if some of my max donors have already donated? Some people have maxed out to me and then are also donating to that. I mean, I'm just curious. I'm just concerned about any potential loopholes. That's all.
Yeah, they couldn't, since you have a regulated committee, the $6,000 limit for transfers would apply. So that wouldn't be an issue. But in terms of distribution of surplus funds and an exploratory committee, that may be something Jared can talk about.
So right now, it's outside the regulatory scheme and a little bit of my my authority. So the regulations that we drafted were basically trying to explain where the line, where you cross over into campaign finance activity, where you become a regulated entity. So that's why the current regulations, we don't really talk about disposal of funds because I have no authority to tell anybody how to dispose of those funds. I can't require any sort of reporting obligations of the activities right now. The only thing that I can say is what you can spend your money on, which is we said that as a non-candidate, if you do certain activities in this area here, this is not going to be deemed campaign finance activity for you to register. But as soon as you cross over and start wanting to become a regular candidate, then you have to open up a candidate committee, you have a bank account, the normal process with a statement of organization. So this has been going on for a long time. We've had Attorney General opinions for years. It was on the summary guide where I basically said, you know, we don't have any statutory authority, but this was kind of the guidance. And then I would say this year or last year, I just codified that guidance into regs to make it a little bit stronger. And then this basically came out of that process here with the delegate taking the lead to kind of help codify or at least put more teeth behind it, behind the exploratory committee. So it's kind of a grayish area right now that we've seen on the rise with more and more candidates that are, not that are coming from outside first time runners rather than other ones.
And this is, I guess, rhetorical. I don't need to comment on this, but just my thought. I just want to make sure that, in case and again, we always have to consider worst case scenario. Say somebody says they're going to run for county executive in Hartford County, right? And then they raise a bunch of money and then they decide not to run and just give that money to candidates across state. I want to make sure that doesn't get facilitated. That's all. Or the best effort we can do to stop stuff like that. So thank you. Thank you, Madam Chair.
Thank you, Delegate Feldmark.
Thank you, Madam Chair. I just want to make sure I understand. So currently, if someone forms an exploratory committee, they can raise money into that exploratory committee. And then let's say they decide to run. Within the same cycle is once they open their candidate committee, are they limited by what they received in the exploratory committee, or they're not limited? Are the donors limited in any way, or do they still have the 6,000 max for the cycle? They still have the 6,000 max for the cycle.
Yes.
And does that change? I'm sorry.
Yes, you're correct.
Dana's making before and after gestures that I'm not sure I followed.
If I may, Stan, a donor could give to an exploratory committee and then turn around and give another $6,000 to the candidate committee. Is that where you're going, Delegate Feldmark?
Yes.
Yes.
So they're double downing.
I'm sorry. So they currently can, and after this bill, they would still be able to or would not be able to?
Would not, as it's currently drafted.
So it's making it one continuous contribution tracking for that candidate, whether it's exploratory or campaign.
As it's drafted, but I think Delegate Jones has her amendments would change that, and she should probably speak to that.
Okay, so I guess that's the piece I missed. Sorry.
I apologize. May I, Chairwoman?
Yes.
Thank you. The amendment is in your inbox, all of you right now. Sorry for the problem with the ether. And as some of you continue to sound like robots on my end, it appears as though the MGA Wi-Fi is letting me down again. I just wanted to be clear that some of the reasons that we did this is because we were going, and I should actually let Mr. Demarina speak to this, but really highlight the fact that we have been going off guidance from a past Attorney General ruling, that we do not have this. There isn't the transparency, there isn't the guidelines. And so this bill would be putting that in there. Like it appeared to me, and excuse me for my not legal way of doing this, but exploratory committees and draft committees were in this middle earth place where we weren't necessarily seeing and having the transparency and tracking this the same way that candidate committees were. So that is where this came from, if it wasn't made clear prior.
Actually, Delegate Jones, if it's helpful, I think it might be good if Mr. Demarina is in a place to walk us through the reprint. I received it, so thank you. And maybe we can walk it through, we can chew on it, and then we'll definitely have this bill for discussion again. And also, but before you walk us through, Mr. Demarina, can you say, are draft committees, are we creating the term draft committee, or is that already a defined term and a defined thing in our statutes?
It is not defined in the statutes. It's just through regs right now. So these new terms of our and new definitions. And mentioned to me, I do have some regs on what you can do with the surplus funds with an exploratory committee to kind of like give it back to their donors and everything else. So I just wanted to, I forgot to mention that. And I'm trying to get the amendments now here coming in. I don't know if my internet is slow or not.
I just hit forward as well, so hopefully you'll have it in a second.
There we go. Okay. All right, I got them. Yes, thank you. All right. So as we go through this bill here, I don't know if Stan, did you want to help or me, Madam Chair? Either one of us can do this. I'll be happy to walk through it here if we want to go page by page or.
Yes, I want to try to finish this bill in the next 5 minutes though, because I want to make sure we get to the next one, which might have a lot of discussion. So let's just do more of a top lines for us.
Yeah, and I defer to you, Jared, on this one.
Sure. Okay. So basically, the first part here was just on page 3 was just a clarifying that, you know, rather than a political committee, it applies to an authorized candidate committee. It's just making it a more precise term of art there. On page 3, this is where it kind of starts really getting into the meat of the matter here, which is about what it can make expenditures on and disbursements on, and that's starting on line 9 on page 3 there. So right now, it was just more or less what we did was just conduct surveys or polling about the viability or direct mails about, you know, communications with potential voters. But now it's giving it that these committees can actually get space and get, you know, equipment and computers and, you know, basically have an office for this activity here. And one of the things is that, you know, if at the end of this process here, if the potential candidate wanted to move and become an actual candidate and run for an office, that it allows for the purchase of the equipment and space and those activities that the draft committee or exploratory committee did, that the authorized candidate committee can purchase those items at fair market value. So it just defines that, you know, basically that the committee can, without getting a contribution, you know, make sure that it goes over there. And then it has 120-day window for basically what the candidate can before if the candidate never files for office or does not seek to run in any sort of fashion, it basically put a time limit on the disbursement of surplus funds and to whom it can be to whom it can go to, which is back to its contributors, or it can go to the state and central committee of a political party, and also it would basically to nonprofits, the Fair Campaign Finance Fund. This is very similar to how political committees currently dispose of their political funds when they seek to close out and no longer want to run for political office. So this is in line with the surplus fund statute that we have. The only difference is that it puts a time frame on it of 120 days to, for these committees. And the rationale between, I think that the difference is these committees were basically, they're not long-standing entities. You're not going to have an exploratory action for more than a year or so. So and that's on the outside of the length of it. But so 120 days to dispose of its funds is a reasonable, I would say, process to get out of leases, making sure whatever staff or whatever has to be paid, and moving forward with it. So that kind of sums up the amendments right now for it on this process. So as a high level.
So most of that was about the draft.
Yes.
The draft
right.
committee.
Yes, this is all about draft committee and disposing of funds and basically increasing some of the activities in which a draft committee may make expenditures on or disbursement.
Yeah. So I have to say I'm not 100% sold on the idea of these draft committees and us encouraging it and putting it into law and things like that. I'm kind of the persuasion. I mean, if you have to do all that, get a campaign office and equipment and all of these things to draft someone, I mean, that person should just run if they're interested. It seems like a lot to do to draft someone to run for office. It's very interesting. But we can talk more about the idea of draft committees for sure. I really like the idea, though, of for our exploratory committees in particular, making sure that we have, I think our favorite term in the Maryland General Assembly is guardrails, but that we have some guardrails put on for our exploratory committees. I think we can tighten that up a lot. Delegate Jones.
Thank you so much, Chairwoman. And the reason that draft committees are in there as well as exploratory committees is really because there isn't, to use your term, the guardrails, there isn't anything around them, and they are able to do this now without any transparency or reporting. And so really applying the same transparency and reporting that we have for candidate committees to them as well is really just cleaning up, was where we were going with that. So thank you so much for the opportunity.
Yes, absolutely. I'm glad we're able to walk through the amendments. I'm going to ask the committee members to review in advance of the next time that we discuss this bill. And we now have these in our possession, and we'll figure out where to go from here. It's an important bill, so thank you, Delegate Jones. Let's move on to our final bill for discussion today, HB 535, Election Law Ballots Processing and Reporting Procedures. This bill is one that the Maryland General Assembly passed, at least this very similar bill, last year. It was vetoed by the governor. Am I correct? Yes. Vetoed by the governor. So we are back again with it. As everyone may know, certain provisions of the bill, the boards of elections, because of last year's election, had to petition the courts in order to get things like being able to process ballots early. So we want to make sure that we get this in statute. In terms of
this bill, it includes the ballot curing provisions where Board of Elections has to review the envelope for emission of a signature. They have to contact the voter within a certain amount of days, give them an opportunity to cure. There's a deadline by which the voter has to cure in order for their ballot to be counted. It also includes ballot tracking so that the voter, for mail-in ballots in particular, gets that notification that a ballot was received. It includes 8 days processing in terms of being able to start processing processing ballots for the local boards of election, which starts on the last day of early voting, 8 days before the last day of early voting, I should say. Are there any changes, Stan, from the bill that we passed last year? Is this the same exact bill? Delia Feldmark is saying no, there are changes. So if you share what the changes are.
I'm sorry, Madam Chair, did you want me to do that or were you asking Stan to?
You can do it, Delia Feldmark, that
Okay.
works.
So, and Stan, correct me if you think I'm missing anything, but just there's 2 basic changes. One is for the local boards to record the receipt of the mail-in ballot. We're saying as soon as possible within 2 business days, so setting a limit on how quickly that has to be recorded in the system so that people will know their ballot was received. And then the second change is last year's bill simply allowed the local boards to start processing up to 8 days before early voting. This actually says that they shall, but it also provides for the state board of elections to be able to grant a waiver if the local board has such a small number of mail-in ballots that they don't need the additional time to process them. So it is a requirement with a little flexibility if they go to the state board.
Okay. Stan, just anything before we go to, Delegate Griffith, I was already looking at you. I know you have questions. We're gonna have a good discussion. But Stan, was there anything else to flag in terms of the overview of the bill? I'm just making sure we captured everything.
I don't think so. It is last year's bill. So yeah, nothing to add.
Okay, great. Delegate Griffith, floor is
So we're not
yours.
gonna have a ton of discussion. I mean, the subcommittee and committee has been very gracious to allow me for the last 2 years to express my opinion. And I'm sure you're tired of hearing me say the same thing over again. Just one last clarification question on this for Mr. Demarinis. So what marks or signatures can be used to qualify as a signed ballot? Because I've talked to some election officials offline. They've said their interpretation is if it's just like a line or a scribble, that they may have to consider that a signature. What is your guidance or interpretation of what marks in the box count as signature?
I'll answer that, Madam Chair. Or?
Yes.
Okay, just basically, if the voter makes an indication of their signature on the line, then that would be considered a signature by the voter. So whatever their signature is, it could be a line, it could be an X, it can be, I mean, mine's pretty much scribble. So it's whatever the voters, I would say, line and what they would constitute a legal signature for processing.
Thank you, I appreciate it. And this gets back to my overall point. You know, it's tough for folks on my side of the aisle to talk about election security right now because that conversation's kind of been hijacked. And so anytime we talk about like signature verification, you know, some people think we're talking about, you know, challenging the validity of election, which we're not. So it's hard to have that conversation without people thinking we're talking about something completely unrelated. so I want to make sure I'm drawing a very bright distinction. So that's just that's my overall concern with the bill, is just without positively identifying the signature, mail-in ballot coming in, the opportunities or misunderstandings, or even taking away an individual's opportunity to be proven wrong, that yes, you did vote, and no, you cannot vote again. So that's my only thoughts. I appreciate all the conversation, the opportunity to express my concerns on the bill. Thank you.
No problem. Thank you, Delegate Griffith. Delegate Miller.
Yes, and I wasn't here for all the previous discussion, so if I apologize. Thank you, Madam Chair, if I am going rehashing things. So definitely the same concerns as Delegate Griffith. The other thing is about so if the only way they would contact a voter is if that line was blank. Is that correct?
Yes, I believe so.
Yes.
Okay, so if it was blank, and so when we're talking about legal signature, it's not the legal signature that they have on file with the MVA when they sign up to register to vote, and they have like the legal signature, or wherever they sign up to vote, that's not their legal signature. So if the mark that they use to sign their ballot does not match what they have as their legal signature, even like on their driver's license, that would not prompt any kind of reaching out to the voter.
You're correct, Delegate. They do not try to match the signature that they have on file in the voter registration system with the signature that the voter puts on the envelope. That is correct.
Okay. And then so a lot of the complaints that we heard or that we were hearing at the polls was, a voter showing up to vote and being told they already voted, and then so they have to file the whole provisional piece of it. So if if a voter shows up to vote and they say that their vote's already been cast in early voting and it's already been counted, right? Because we're going the early process. So then they file their provisional ballot. Which ballot would be then considered accurate? So do you see what I'm saying? Like, if they filed that appeal that they didn't cast this vote, how do you determine which one is the actual vote?
Thank you, Delegate. That's a great question and a really key part of the bill that we haven't talked about yet.
Oh, I'm sorry.
No, because we should have mentioned that part. So Stan, if you can explain how the bill addresses that.
Sure. So that's there's language in the bill. If you look on page
6,
lines 20 through 25. So basically, it requires that the first ballot determined to be legally sufficient be the one that's counted. So that is going to be the mail-in ballot in almost every case, because it's going to be received first and processed first.
Okay, that's a lot for me. I might have to have some extra conversations about that, because that's a lot for me in my reasoning state of mind to go through. So Madam Chair, can I reserve the right to have that conversation with
Yes.
Jared or something? Because that's going to take a
Yes.
while for me to get through that, talk through that
Yes.
process.
Yes,
Right.
Delegate Mill, only because we have gone through this for a couple years in a row.
I got you.
Problem. No problem at all. But if you're able to talk to either Stan or Jared or even Delegate Feldmark to understand that rationale and how it would work offline, I think it would. I completely understand. And
I appreciate that. Thank you.
Awesome. Perfect. So the one other thing that I am thinking about in this bill as we're discussing it is that we do have an opt-out provision. I'm also wondering for counties like my county, Montgomery County, we get the most mail-in ballots, and 8 days may not be enough. So the same way that someone can waive out, we might want to have a provision for a county to waive up. in terms of the number of days, because I think we've all seen even with 8 days, some jurisdictions might need even more time, but I know the number of days has been quite a cause of consternation for us to figure out. So we'll have some offline conversations about that. Any other questions, comments, concerns, Delegate Feldmark?
Thank you, Madam Chair. And I just wanted to raise as a reminder, because I do think it's something we should consider and discuss and decide how we want to handle it. You know, we did have the request for an amendment from Mayo regarding the number of days that the local boards would have to enter the receipt of the mail-in ballots. So it's in the bill at 2 business days as the limit, and they had requested to increase that to 5 business days. I will say my personal perspective is that 5 business days seems excessive when someone's waiting to hear that their ballot got received. They did raise the point, which I can appreciate, that for mail-in ballots in the pre-printed envelopes, right, there's a barcode, so it's a much easier automated process. Whereas if someone has a web delivered, email delivered ballot that they've printed out at home and completed, right, that has to be transposed and is not as easy to, you know, it doesn't come with the bar scan. So, you know, I guess in my mind, maybe I'm open to considering an increase in that case, but I really feel like for the standard pre-printed envelopes that have that barcode that can be scanned, my personal preference would be to keep that time limit as tight as possible.
Okay.
But I just didn't want that request to get lost in the discussion, so I wanted to remind folks of that.
For Stan or Jared on that, when the 2 business days, or is it 3? 2, right? Yeah.
2.
That is when they're putting it into like the computer system, or is that when the voter is getting the notification, or is it instant when it goes into the system? I just want to get the distinction between when the voter actually gets the notification. Is that the 2 days? Either one of you, Stan or Jared.
I don't know the answer to that, so maybe Jared knows.
I'll have to double check. I think that the scan part, they scan it in, and I'll circle back with more of my Mayo individuals that do this. They scan it in, and then at that point there, I think it automatically sends out an email to a person, but I don't know if it's something that they have to push out at the end of the day or something to that, but I'll find out more about that process for you.
Okay, thank you. And Catherine, if I see you are on the line, if you're in a position to share more information, you know, I've always been concerned about the length of time that it takes for a voter to be notified that their ballot was received when they do a mail-in ballot. So I just want to clarify if we are talking about 2 business days for when the voter is notified, or that's just when it's scanned, or if those are the same thing because it happens in real time.
Thank you, Madam Chair. I can answer a part of that question. So when we go through the act of accepting it in our database, my understanding is that there's a nightly push out from the State Board of Elections that notifies the voter right away. But it's as soon as we get receipt, in theory, the voter will then be notified as soon as, that day is complete. So.
Okay, because I might want to, if it makes sense, I don't want us to do too many changes because we already passed this bill. But I do want to look at offline changing it to when the voter is notified, because I think that's what we really care about, is notification that the voter receives, for it to be in the 2 days. So that's something that we will talk about.
Thank you.
Okay, any other comments before we close out?
Madam Chair, can I just mention one thing?
Sure.
Which is that the bill does, it does allow for processing of mail-in ballots before Election Day, but it doesn't allow for tabulation before Election Day.
Great.
So I just wanted to mention that because that was some discussion last year about that.
Thank you. Good point. All right, we're at 11:57. Are there any other comments, questions, or concerns? Delia Jones, I know you were having some internet issues. We see you there.
I am. I apologize, Chair.
No problem, no problem. Okay, not seeing any discussion. I am going to just ask us to take a look at the two bills that we discussed. We'll potentially bring them up again very soon. So please continue to look at those and provide any amendments to the committee if you have any. And with that,